My name is Zachary Ward. I'm a partner at Cowie & Ward. I'm a criminal defense attorney who represents clients in Tallahassee and the surrounding areas. Today's topic will be the penalties for the possession and/or sale of marijuana in the state of Florida. Marijuana is still illegal in the United States of America. The federal government has listed marijuana as a dangerous narcotic since approximately 1906. As you may be aware, many states and the District of Columbia have lately liberalized these laws, making sale or possession of marijuana legal in those states. Florida is not one of those states. Marijuana is still treated as a Schedule I narcotic in the state of Florida, and the penalties can be harsh for possession or sale of marijuana. Medical marijuana is now legal in Florida, but this is causing some confusion. You have to have a prescription in order to get medical marijuana, and medical marijuana is in the form of an oil or a wax that has to be used with a vaporizer. Many stores are now selling CBD oil, which is supposed to be a non-psychoactive cannabis oil to the general public. Under Florida law, that could be considered marijuana or a marijuana concentrate, as there is no exception. So unless you have a prescription card, you should not have CBD oil. It will be illegal. Florida does make an exception to its harsh laws for possessions of small amount of marijuana. Possession of marijuana under 20 grams, which is slightly less than 3/4 of an ounce, is a first-degree misdemeanor in the state of Florida, punishable by up to 11 months and 29 days in jail. But most of the time, the punishment is simply a fine and/or probation. Possession of over 20 grams of marijuana is a third-degree felony, punishable by up to 5 years in state prison. However, if there's no indication that the person is trying to sell or has possession with intent to sell that marijuana, those people are often allowed into a drug court. In most areas of the state, the drug court is a 12 to 18-month program that will allow people to go to meetings, stop using drugs, and eventually have the case or the charges against them dismissed, and they can clean up their record. Possession of over 20 grams of marijuana in the state of Florida is a third-degree felony. That can be punishable by up to 5 years in prison. The sale or possession with intent to sell of marijuana is also a third-degree felony, punishable by up to 5 years in prison. If the sale or possession with intent to sell of marijuana is within 1,000 feet of a school, a church, or other designated special area of concern like a public housing project, those penalties can be enhanced to a second-degree felony, which is punishable by up to 15 years in state prison. If an individual is in possession of marijuana and also in possession of scales, baggies, ledgers indicating sales, that person might be charged with possession of that marijuana with intent to sell, which is punishable up to 5 years in state prison. Possession of drug paraphernalia is also a first-degree misdemeanor in the state of Florida. So if an individual is caught with a bong, a pipe, a roach clip, or any other device used to smoke or vaporize marijuana, they can be charged with a first-degree misdemeanor. If an individual is convicted of any statutory violation of Florida Chapter 893, which includes marijuana, their driving privilege can be revoked for up to 2 years. For more information on the marijuana laws in the state of Florida, or any updates to those laws, or any other criminal defense topics, please visit us at cowieward.com.